Want to say anything? Thank you. Do you want to say anything first, Jody?
No, absolutely not. I'm going to hand it over to you, Sue.
Oh, well, thank you very much. Okay, welcome to the fifth and last, and certainly the one I've been anticipating, of our Let's Talk Law series. This started, the Human Rights Commission is a all-volunteer group. I don't know, it's a city-sponsored group. And our job, I'm the education chair, and our job is to bring information to people who might not ordinarily get it. And that information should be important for living in Greensboro and knowing what's going on. So we appreciate Jody, who has done incredible work, and Liz Lennon, who's also done incredible work to help us do this. Love Jones is the chair, or I don't know her title, but she's in charge of the Human Rights Department of the city. She's been helpful. So we've gotten great city support. And our previous topics are all online. We'll get some links into the chat shortly so you can see the previous sessions. They've been great. We've had legal experts in all kinds of fields tell us things that we didn't know, from what's in the Constitution to how to get an expungement for maybe your kid who committed or at least pled guilty to certain crimes. It's been great. The next season of this will begin in late October, early November, and you'll be getting plenty of information about it. The rules of the road tonight are, please keep yourself muted if you're not asking a question. This is not a formal thing. If you want to ask a question, we're going to say, yes, please, unmute yourself, ask the question. Our presenter tonight, our speaker, we couldn't be more fortunate, is Alex F., who is Effie. Did I get that right?
But I respond to anything remotely close.
Thank you. I have the same thing with my last name. Alex is the head of immigration law, the immigration law practice group and he has been exclusively practicing immigration law in North Carolina since 2012. He practices in a couple of states, or he's licensed to practice in a couple of states, and the Fourth Circuit Court of Appeals and the United States Supreme Court, but we're not going to talk about them tonight. Alex is from Bogota, Colombia, and grew up in this area in the Triad of North Carolina. He's got two very large dogs, a lovely wife and a son, and he attended UNC Chapel Hill for his bachelor's and the Villanova School of Law for his JD. Excuse me. His practice spans all areas of immigration, from family-based to employment-based and removal defense. He's handled lots of cases for citizens and nationals of 50 different countries. Because of everything that's going on with immigration, ICE, their activity in the Carolinas, Alex has been busy. So it's good to know that he's willing to take his time and share this with us. And when he's done talking, we're going to ask you to do one of two things. You can either raise your hand to ask a question, or you can put, if you don't want to speak, you can put it in the chat. We'll ask it for you. But here we go. Alex?
Okay. I just looked at the list of countries because I think you said 50. My list now has 71.
They need to update your bio on your website.
Yeah, that must have been from a while ago before I added a couple more countries. All right. Let me go ahead and share my screen and see if I can get this to work. All right. Okay, so this is Let's Talk Immigration. So this is kind of Immigration 101. I don't know exactly how much background people might have on immigration, but just like Sue said, there's a large area to talk about in immigration. There's employment-based, there's removal defense, asylum cases, there's what's happening with people who are in Ukraine or are coming from Afghanistan, what's happening with kids who may have had Daca, who are here because their parents brought them here. So there's a very wide area and people have varying degrees of interaction with immigration. So we're going to kind of go over everything from a broad perspective. So if you have any questions, I really don't mind them being asked while we're talking about it, because a couple minutes later, we're going to be on a topic that's different than the one I'm on right now. So if you have an idea or have a question about whatever I'm talking about immediately, you can go ahead and ask. I like questions. All right, this is basically just what she said. So I was born in Bogota, Colombia. I will keep this up because I found my birth mother just this year. So I'm going to Colombia next year, the beginning of next year, and I will meet the woman to whom I was born 30 plus years ago. So that's exciting for me. But I have that interaction personally with the immigration system because I was born in Bogota, and then I became a US citizen by being adopted. My wife was also born in Tashkent, Uzbekistan. So she became a US citizen just last year by being married to me. We did her adjustment of status to get her green card, and now she became a US citizen. All right, I kind of wanted to start it off with these two quotes because I think they help put a perspective on what we're going to talk about. So this first one is that once I thought to write a history of the immigrants in America, and then I discovered that immigrants were American history. And I think that's important to remember because outside of Native Americans, nobody who is on this call was likely a truly Native American. We were all brought here at some point, whether it was in the 1800s, 1900s, last year, outside of coming across a land bridge from Asia, we're all immigrants. And let's see if I can figure out how to go back. The second one is about the complexity of immigration. So with only a small degree of hyperbole, the immigration laws have been termed second only to the Internal Revenue Code in complexity. So that's generally pretty true. And part of it is that it continues to change. So policies can change, the laws can change, decisions by the US Supreme Court or different circuit courts can change. So Sue talked about the Fourth Circuit. The law that we apply in the Fourth Circuit, which covers North Carolina, may be fundamentally different than what is being covered in California, which is a different circuit, or in New York. So those can be very different based on the type of law. And I was talking to somebody earlier today about asylum cases, and they were wondering whether it's good to file here in North Carolina. And the answer is no. North Carolina and Georgia are two of the worst places if you have to go in front of an immigration judge, statistically speaking, to have your asylum case. Now, generally, those immigration judges should be seeing the same types of cases. They should also be applying the exact same law for immigration law. And to have such a wide disparity where somebody might grant 70% of cases and somebody else, for instance, in Charlotte, grants less than 1% of all asylum cases that go before them, that's not normal and it's not right. It's just another kind of area of complexity with immigration because knowing the judge you're practicing in front, knowing the court you're going to, knowing the jurisdiction can all change what the potential outcomes for clients might be. All right, I also wanted to start off with a little bit of history. So not everybody might know this, but this is Ellis Island. And for a lot of people, either their ancestors came through Ellis Island or somewhere around there. Up until a certain point, we did have open borders in the United States. And that meant that there was no restriction on who could come or how many people could come. It was just open borders, which I'm sure for a subset of the population, that would infuriate them if that were to happen today. So the naturalization laws changed in 1790. So then you've got 2-year notice that you had to have good moral character and be a free white person. So that goes to show that that was not always the same for everybody. You had to be a free white person. Then you got the 14th Amendment, where all persons born in or naturalized in the United States became citizens. So every now and then during the political debates, you might hear about something called birthright citizenship. So that's another thing that the United States has, where if you are born in the United States, that you are a US citizen. It is one of the ways to become a US citizen. It can also be passed on to you if your mother or father are a US citizen. That also has some complexities because it matters on whether your parents were born, whether the US citizen parent was your mother, or whether they were your father. So there are a lot of complexities even within some of the things that I say. So then in the 1870s and 1880s, to go a little bit into history, we had something called eugenics. So eugenics was this quasi-scientific movement where people thought that they could say that one race was better or more intelligent than the other. And that was often used to enact these discriminatory practices as to who could come into the United States. So for instance, at this point in time, Asians still couldn't naturalize and become US citizens. Right, so Ellis Island actually had a fire and a lot burned down. And this picture here is the second immigration station that was opened in 1900. There's an extra zero there. All right, very quickly, so the laws have changed over time. In 1917, they added a literacy requirement. Then there was, in 1921, we started doing something called quotas. The idea was that we didn't want every single immigrant coming from Ireland. We wanted people coming from multiple different countries. And so that was the beginning of this quota system. It got more complicated as time went on, and we still have that today, which is something I'll talk about a little bit later on with something called the visa bulletin, where somebody from India might have to wait years longer than somebody who's from Uzbekistan or somebody who's from Chile. So fast forward a little bit to now, and this is more or less the immigration law that we have been operating under since 1996. There have been some changes with how things are interpreted. There are changes with policies. There are memos that come out, but for all intents and purposes, we are still dealing with the 1996, people will call it IRA, but it's the Illegal Immigration Reform and Immigration Responsibility Act. So one of the things that this did is it vastly increased the criminal grounds for inadmissibility. So what inadmissibility is when you apply for a benefit, whether it's to get a green card or to naturalize, you have the burden to prove that you are in fact admissible, able to be admitted to the United States in the status in which you are applying. And then I just see, okay. I'm not really watching the chat, so if any of the questions come up, I saw a couple things go in there, you can just let me know that there's questions.
I'll let you know.
The criminal grounds, that could have been whether a person had misdemeanors or whether they had a conviction for a felony or whether there was domestic violence. So any of those things could now make a person potentially inadmissible, and they can also be grounds for removability. So admissibility is the ability to come in and to get a status. Removability is the other side of that coin. It is the ability of the United States to take away whatever status you might have, or if you have no status, to order you removed from the United States, which is to then potentially take you into custody, you're in immigration detention, and then eventually you are sent back to your country of origin. It also established grounds for mandatory detention. So for instance, if a person has a drug conviction, if they were caught with whatever the smallest amount of cocaine a person can have, that is subject to mandatory detention because it's a violation of our controlled substance laws. It also established something called the permanent bar. So the permanent bar is one of the harshest consequences in immigration. And there are two ways to trigger it. The first one is if a person comes without permission and they're here for over a year, they have over a year of unlawful presence. Unlawful presence means they were here without permission. Or a person comes with a visa, like a tourist visa that lasts for 6 months. 6 months later, they decide they don't want to go home and they're still here. They start to accrue unlawful presence at that point. Again, if they have over a year and then they leave to go back to their country of origin or any other country, if they try to come in a second time unlawfully, then that would turn into a permanent bar. Or if they have over a year of unlawful presence, then they get ordered removed. Or if they get ordered removed and try to come back in again unlawfully, that will trigger a permanent bar, which means they cannot apply or get any status within the United States, with a very, very few exceptions, unless they have been physically outside of the US for 10 years. Where I often see this is I'll have clients that will come in and they may have come in the 80s or 90s or early 2000s. And let's say 2009, their mother or father got sick, or their family needed them to come back and help for some reason. when they went back to visit their mother or father who may have been dying, that triggered that 10-year bar. And then they still had to come back into the US because they may have had children here, or they may have a spouse or other things that they were doing, or they were working to make money and sending that money home. That second reentry, if they come back in unlawfully, now triggers a permanent bar. And now let's say those US citizen children grow up and they're over the age of 21 and they want to file a petition for their parents. They now can't do that. They can't get status because of the permanent bar. Or they get married to a US citizen, or their US citizen spouse joins the army and wins the Medal of Honor. It still doesn't matter if they have that permanent bar. There's really very little that a person can do to overcome that. And it's a very harsh consequence because people often trigger it when they're younger or years and years before they actually have any viable form of relief. And then when they come to me, it's oftentimes a little depressing to have to explain that to people. So one question is, how is detention different than incarceration? Some of that has to do with terminology. So technically speaking, much of the things in immigration are not crimes. They're civil violations and they're enactments of the INA, which is the Immigration and Nationality Act. So for instance, the person who comes on a tourist visa or a student visa, if they overstay that visa, they are now here unlawfully, but it is not necessarily illegal. It's not a violation of certain laws. And oftentimes when somebody is called illegal as a person, it's essentially a misnomer. So a civil violation is different, and the immigration court proceedings are different than criminal proceedings. One of the ways you see that is that you're not entitled to have an attorney when you go to immigration court. If you're charged with even a minor crime, in criminal courts, you have a right to an attorney. You have a constitutional right to representation, and you do not have that in immigration court. And so oftentimes when you see somebody coming as a minor, or these groups of minors that we've seen currently, and especially in the news over the last couple of years, those individuals, you might be a 6-year-old girl from Guatemala who does not speak English, and you have no right to an attorney. You have to do your best to try to struggle through an immigration court proceeding to claim any form of relief that you may or may not have as a 6-year-old who doesn't speak the language, because you have no right to counsel. Now, there are some people who try to volunteer their time and volunteer to be attorneys for those individuals, but there are far more individuals than there are resources to kind of help them at low bono or pro bono basis. All right. I think that answered that question. So with minor changes and exceptions, this is the law as we have it now. And again, there is no right to counsel. So can a permanent bar be overcome? Yes, a permanent bar can be overcome, but the person has to be physically out of the country for at least 10 years before they can even ask for forgiveness. So I talk about it a little bit later on, but since it gives you context, I'm going to also talk about something called the 3 and the 10-year bar. So the 3-year bar is triggered if a person has been here for 180 days or more without permission, and then they leave. They're not supposed to be able to come back in without permission for 3 years. Now, if that person has over a year of unlawful presence and then they leave, they can't come back in for 10 years unless they either wait that time out of the country or they get a waiver. That permanent bar is that 10-year bar that's made permanent by a second unlawful reentry. So if you have a 10-year bar, you can just wait out the clock. And I do have some clients who are doing this. I have one now who triggered a 10-year bar, but he's now been out of the country for almost 20 years. So he has run the clock on that 10-year bar and is able to come back in without being inadmissible. But I also have many clients who triggered a permanent bar, and they might have a 5-year-old and a 10-year-old. And in order for them to be able to get a waiver that they would need to overcome that bar, first they would have to leave. We're in 2022 now. So sometime in 2032, when that 5-year-old is 15 and the 10-year-old is 20, then they would be able to ask for a waiver. Getting that waiver is still going to be difficult. There is no amount of time that you can wait out of the country that removes your need to have that waiver when you have a permanent bar. So it can be overcome, but it's very difficult. And oftentimes, if you're dealing with somebody who might be a neighbor or somebody who's here in the US, then for them to even envision beginning to overcome that bar, you're going to have to ask them to leave their family and everything that they've known. and you have no idea whether the waiver that they will eventually apply for a decade from now will be granted or not. So most people opt not to leave and kind of take their chances a decade from now, because that's a lot to ask for someone. Pop quiz. These are random questions that I selected with a random number generator from the 100 questions for US citizenship. So when you apply to become a US citizen, there's an English language test where you have to prove that you can read a sentence in English, write a sentence in English, and there is a civics component. The civics component has 100 possible questions, and of those 100 questions, you have to get 6 out of the 10 that they ask you correct. There are some exceptions for people that have had their green card for a certain number of years and are over a certain age. But for fun, let's see how good everybody does with these. So the answers to these questions are further along in the slides. But the first one is, we elect a president for how many years? And you can either write it down or just think about it in your head. And then what is one reason that colonists came to the United States? They came to America. David's right for every answer. He says to make money. I think that's why we elect a president too. But name one American Indian tribe in the United States. And how many justices are on the US Supreme Court when there's a full bench? And that's a good answer too. What is an amendment? So I'll give everybody just a second to kind of think about those, but those are questions that are coming. And remember, there are one of 100 questions that are possible. And no fair Googling the answers. All right. Continuing, there are different areas of immigration. So there are family-based. I do a lot of family-based immigration, and it's probably what most of you will think about when you think about immigration. It is somebody who gets married to a US citizen. For instance, my wife got married to me, and I was able to file a petition for her, establishing that it was a real and true marriage, and that was the basis under which she got her green card. That is family-based immigration. Now that she is a US citizen, she has the ability to file a petition for her mother, who is in Uzbekistan. That is also family-based immigration. She's an immediate relative, but from start to finish, that process is probably going to have taken us 2.5 to 3.5 years before her mother gets here. I have a 10.5-month-old baby that we were hoping she would be here to be able to meet, but when her mother applied for a tourist visa, that was denied. And it was denied in part because we had that I-130 already pending, which shows the person does eventually want to immigrate to the United States. Now, as for that tourist visa, she was only going to come and visit, and she was going to go back home. So she really didn't have an immigrant intent as to the time that she was going to travel then, but it still got denied. And that happens to a lot of people. I went through a lot of pains to make sure that immigration understood that she understands that this is a non-immigrant tourist visa she's applying for. And even with all of that, that still got denied. And my son will be 2, almost 3, before she actually has a chance to meet them. So as I'm talking through all of these, you can kind of visualize that these do affect people's lives. So during the pandemic, it was hard to have daycare. And so had my mother-in-law been here, that would have been very, very useful to us. It would have kept her safer, it would have kept our family safer. And that happens to untold numbers of people applying for their siblings, applying for their spouses, applying for their parents in the United States and in every other country across the world. So David also asked in the chat, are the answers fixed or can something be close, be right? So for some of those questions that we had before, the answers can be numerous. So for instance, in the Native American tribe, there, you could say Iroquois, you could say the Lenape, which are the Delaware Indians, you could say Cherokee. So there are multiple answers. Some of them do not have multiple answers. So some of the questions will be, who is the president or who is the vice president? Those have a solid answer. Or who is one of your senators? You're only going to have 2 possible options. As far as whether the immigration officer will let something that is pretty close slide, that often kind of depends. So when you go and do your naturalization interview, it is another human being that is asking you those questions. And they can kind of tell whether a person might be struggling with the English, or they were very close, or they mispronounced something. So oftentimes you will get an officer who is lenient and kind of gives you the benefit of the doubt. But because they have that level of discretion, you can also have somebody who really doesn't do that. And if you don't get it right, they're going to consider that answer to be wrong. So yes and no, there can be some answers that are fixed and some that are close. The next area is employment-based. So employment-based is, let's say you have a employer who needs someone to come and start a business, or they need someone to fulfill a certain job. One of the examples I often use is if you are an Italian shoemaker and you want to start a business here, you might need somebody who has that level of experience in shoemaking and the way those things are done to come over here and explain how they are done to kind of start that US-based business, because the people in the United States might not have experience in how these things are done. So you could bring a manager or executive over to kind of work on starting that. Or you might have something like an H-1B, where somebody is needed because of their expertise in engineering or in some other field. Or you might have any other form of employment that there are not enough US citizen or lawful permanent resident workers to do. Another example might be in Florida or any vacation destination. Most US citizens are going to want a job that lasts year round, but you also sometimes have seasonal jobs where you're going to have a high season and a low season if you're at a ski resort or if you are at a beach. So most US citizens don't want that job for only 3 months or 4 months or 6 months out of the year. So oftentimes an immigrant might come where they can work those 6 months and potentially make as much or more as they might have made for a year working in their home country. And it also benefits the United States because now those resorts get to stay open. People get to go to their ski resort. People get to have their vacations in a way that they couldn't when you're lacking that immigrant working presence. It is some of what we actually ran into with the pandemic, with people not being able to find enough workers to work in fields and on farms and other places. So the pandemic did also expose a lot of the weaknesses in our US employment-based system, where even now you're not having as many people that can do a lot of the jobs. And so that's something that affects everybody. There's also a question that says, why is understanding English a requirement to pass the immigration test? The US doesn't have an official language. So that is true. The United States does not have an official language, but I think it's just about the level of being able to perhaps interact, because it is not required in order to get a green card. But citizenship is that extra additional level, because once you have it, it cannot be taken away. So there is no English language requirement or civics requirement or any of that to have and get a green card. And many people are perfectly happy with that residency for the rest of their lives. It allows them to travel in and out of the United States. They can get a social security number. They can work legally. So they have almost all of the benefits with the exception that they can't vote. And a green card can still be taken away. A person can choose to abandon it, or it can be taken away by you being put into removal proceedings. Citizenship doesn't work that way. Once you become a US citizen, unless you obtained that citizenship through fraudulent means, it's not going to be taken away from you the same way that a green card can be lost. So it's a higher burden to become a citizen, but even that English language portion can be waived. So again, if a person is over the age of 55 and they have had their green card for 15 years, or they're over the age of 50 and have had it for 20 years, I believe those are the correct numbers off the top of my head, that they do not have to pass the English language requirement. Over the age of 60, you can actually get a reduced number of questions that they're going to ask the civics questions for. So there are kind of some exceptions. So a person could still become a US citizen by speaking no English, but they'd have to be here for a fair amount of time before they could do that. Removal defense. So these are ones where somebody does get put into removal proceedings. So that immigration judge, for instance, our court is in Charlotte, North Carolina. So if a person is in front of an immigration judge, they can represent themselves. They can also apply for themselves with USCIS. So essentially everything that an immigration attorney does, a person can do on their own, but it's hard. So navigating removal defense, particularly being in front of some of the judges that we have, can be very stressful. It can be very hard and can be very confusing. And in immigration court, you have an opposing side. So you have the Office of Chief Counsel that represents the government, the Department of Homeland Security, and their job is essentially to see the person removed and to challenge whether they are actually admissible or have any form of relief. People often end up in removal proceedings because of crimes or because of something that they may have done wrong, but they also often end up in removal proceedings for being in the wrong place at the wrong time. I've had a lot of kind of tragic stories where maybe the person who lived in a house before this family lives there, maybe they had a problem or they had a violation of the law. And when Immigration and Customs Enforcement came to look for that person who lived there 4 years ago or 2 years ago, now they find a family, a mother and a father, and 2 kids from Nicaragua, and then they all end up in removal proceedings, which is possible if they're here without permission, but was not likely to have happened, but for them having to have lived in that house. So oftentimes a person is just in the wrong place at the wrong time, and that is the impetus to put them into removal proceedings. Because there are many, many people here in the United States without status or who have overstayed their previous status. And every single one of them can be put into removal proceedings, regardless of whether they have any criminal record at all. But the United States doesn't have the resources to remove everybody. And so what you're needing those agencies to do is essentially exercise their prosecutorial discretion. The general idea being that it is in the US government and the US citizens' best interest to go after somebody who is a drug dealer or who is a violent criminal instead of spending all of your time trying to deport the single mother of 2. That is prosecutorial discretion. It's one of the things Sue had asked about a little bit earlier, if there were any changes in immigration law recently. And that's one of the areas where there really has been. So the current administration published 2 memorandum that kind of explained how the government was supposed to exercise its prosecutorial discretion. And I'm not getting ahead of myself because I really don't have a slide on this because this is pretty new. The Fifth Circuit basically said that, no, we shouldn't use any of that. In case anybody is curious, the Fifth Circuit is where Texas is. So they said that they were not going to use it. Then the Sixth Circuit said that they could go forward and they kind of could use it. So you've got a circuit split over whether the government has the ability to use that prosecutorial discretion and to what extent they have that ability to use it, whether anybody should be following these memorandum. As it stands today, we are still getting some prosecutorial discretion where the government might agree to dismiss a case, but not along the lines that we would have when we were operating under those memorandum for a month or 2. Because the memorandum made it very clear that it was that the government should, where at all practical, err on the side of prosecutorial discretion because the cases are dismissed without prejudice and they could always bring them back. But there is an enormous backlog both with USCIS and with immigration court. And that is keeping a lot of people from being able to have a timely day in court or timely adjudication of their applications. All right. Then there's miscellaneous. Miscellaneous is pretty much everything else. So there are a lot of other different things that you can do in immigration that I'll be talking about as we go along. All right, immigration statuses. This gets again into a little bit of the terminology. So for somebody who hasn't had a lot of involvement, most people would know what a US citizen is. US citizen is probably just about everybody who's tuned in here. They are somebody who was born in the United States or obtained citizenship like I did by being adopted. Can you speak more specifically about some judges that we have? I can speak more specifically about some judges that we have, but since this is recorded, I'm not going to because I still have to practice in front of some of those judges. Yeah. So maybe at some point, if Martha Wood wants to talk to me about some of the immigration judges not on a recorded Zoom call, then we can do it at that time. All right, but lawful permanent residence, this is also sometimes called an LPR, or the shorthand is people will say have a green card. So green cards did really used to be green, so, and they still are. So you've got a green card means that you are a lawful permanent resident. You are allowed to stay here in the United States legally, and you can do that for the rest of your life. Or you can apply at some point to become a US citizen. Many people, including at least one person on this call, had opted to remain a lawful permanent resident for a very long time, and only decided that it was really kind of a better idea to become a US citizen when circumstances kind of made it so that it might be a little bit safer than just having a green card. It also gives you the ability to vote. So if you are politically so inclined, as a lawful permanent resident, you will never be able to vote for federal elections. But as a US citizen, you have that right to do that. A non-immigrant. So a non-immigrant is a type of visa. That means that tourist visa example I gave, or a student visa, those are people who have to have and maintain a non-immigrant intent, which is an intent to go back to their country of origin and not to immigrate to the United States. The converse of that is an immigrant. So somebody who has immigrant intent plans to come and stay and demonstrably stay in the United States for quite a while. That, again, going back to the example I used for my mother-in-law, part of the reason she was denied for that non-immigrant tourist visa was because we had already filed the I-130, which is the first step in a person getting an immigrant visa. So those two are generally a little bit kind of inconsistent. So despite our assurances that she was still maintaining non-immigrant intent as to that entry, it was still denied. Another question is voting. What kind of issue can voting in an election cause for? Oh, don't do that. What kind of issue can voting in an election cause if you are not supposed to have voted in an election? So if you vote or register to vote for a US election, in order to do so outside of, I think, maybe some local council or school board or some minor elections, then you're claiming to be a US citizen. And the registering to vote and that claiming to be a US citizen, there's no waiver for that. You can timely try to retract your false claim to US citizenship, but outside of that, it is just the kiss of death for doing just about anything. They can take your green card away and it will keep you from being able to naturalize essentially forever. So registering to vote or claiming to be a US citizen, whether it's on an I-9 form or on a voter registration application, that can end your US journey to anything. And it's one of the things that can be difficult because many people, when you have voter registration drives and people come to your house, they're going everywhere, or they're sitting outside of Walmart. And when this family member goes shopping, this nice person talks to them, they hands them a voter registration card or application. They say, fill it out, or let me help you fill it out. And once that's submitted, that's a false claim to US citizenship because they're signing that form and the application, and that can be extremely, extremely damaging. All right. Next, you have lawfully present. So there can be some people that are here in the United States with lawful presence. So they essentially have permission to be here, but might not have a specific type of visa. So for instance, Daca. Daca is deferred action for childhood arrivals. Many people that you guys might know have children or young adults who are Daca. They came because they were 7 or 8 years old and their parents might have brought them, or they were 2 years old and their parents carried them across. So they didn't really have much of a choice in the matter. A 1-year-old, a 3-year-old, they're not making all of the life decisions on where they're going to grow up. They are essentially at the whims of their parents. What Daca did is in 2012, if on June 15th of 2012, you were present in the United States, you could demonstrate that you either finished high school, were currently in high school, or have a GED, that you have good moral character, so no felony convictions, not more than 3 minor misdemeanor convictions, and that you have been continuously present since June 15th, 2012, then you could apply for Daca. And what that did is that gave people the ability to come out of the shadows and to have work authorization, to have a social security number, to many places go to college, and in some states even to get in-state tuition. It enabled them to get a driver's license. Oftentimes, a lot of the kids who have Daca, they might have grown up thinking that they were US citizens, and they didn't even realize that they weren't, or that they were different from their classmates until years later when they wanted to go to college, or they wanted to do something else. So this made a very big difference for about 800,000 people that have applied for Daca. So yes, green cards are issued for a specific amount of time and they do require renewal, but the actual status does not. So once a person becomes a lawful permanent resident, they have that status until an immigration judge takes it away, or until they voluntarily choose to give it up through their actions or just filing an application. Green cards will be valid for one of two dates. One would be for 2 years. If a person has a 2-year green card, then they have what's called a conditional green card. That means that person likely obtained that green card through marriage and that they had been married for less than 2 years as of the date of approval. That is a way for the US government to fight immigration fraud, because it's one thing to pretend to be married for a couple months to process an application. And for anybody who's been married, you know, it's a very different thing to actually be married for 2 years. So that is the way they fight immigration fraud, because anybody can fake it for a little bit, but 2 years, that's a while. It's hard enough to do when it's real. I'm guessing it's even harder to do if it's not real. So if a person has a 2-year green card, 90 days before the 2-year mark, they will have to file with their spouse jointly to remove the conditions, or they'd have to have another basis to remove it, such as they were a victim of domestic violence, or they would suffer an extreme hardship if they aren't able to remove the conditions without the other person, or if they're legally divorced at that point. And then they would still have to prove that even if we're divorced, even if this marriage has ended, it was a valid marriage when we entered into it. So that's the 2-year card. And then most of the time people have a 10-year green card. And every 10 years, you're right, they would have to apply to renew that card. But even if they didn't, if I had a 10-year green card and I opted not to renew it, I'm still a lawful permanent resident 40 years later. I just lack the proof that I have that status, and I lack a lot of the benefits, because many of the benefits run with the card, that international travel, the work authorization. Whenever you go to an employer as a lawful permanent resident, you have to demonstrate that you're legally able to work, and that's what the green card does. So status is different than the benefits that run with it, because they run with the card. So that's a good question and kind of a nuanced one. I probably gave you more details to that question than you really were looking for. All right. There's also things like TPS. So TPS, I'll give you the example of Ukraine. So Ukraine is the most recent country to be designated for TPS. So technically, just a couple of days ago, we are going to renew TPS for Venezuela, but the most recent initially designated country is going to be Ukraine. So as many people know, I assume everybody knows, Ukraine is currently being attacked by Russia. So they have been under attack for quite a while. And TPS was designated for Ukraine so that people who are from Ukraine and were physically in the United States, I believe as of April 11th, 2022, became eligible to apply for temporary protected status. The underlying premise there is that their home country is not in a position to repatriate those individuals who are in the United States. And there are many countries that have been designated for TPS, El Salvador, Haiti, when they went through either civil wars or earthquakes or some form of natural disaster, or in this case, being attacked by an external aggressor. So that temporary protected status will allow them to have that status for sometimes a year, sometimes 18 months, but it allows them to get work authorization, to legally stay in the United States, get a driver's license, social security number, while they are currently unable to return to their country of origin. Given the scale of destruction that has happened in Ukraine, I expect that TPS for Ukraine is going to be extended for quite a while. TPS for El Salvador has been going on for about 2 decades. So even though it says temporary and temporary protected status, as long as the underlying condition exists that the country is not able to repatriate those nationals who were in the US at the time, then it should likely be redesignated. Undocumented. So that is just somebody who really has no status. So they don't have a formal status like one of the ones above. Illegal is really more or less kind of racist. So who uses it? Why do they use it? It's really done kind of to show a political agenda, because I don't think any human being can actually be illegal. Like if you have ever gotten a speeding ticket, anybody who's on here, we don't go around referring to you as being illegal because you once violated a traffic law in Maryland. That is just, it's not how human vernacular works. It's not how our concept of legality works with people. So it's usually meant as a way of terming another person as other, or making that person seem like they are a criminal even though most of the violations that exist in immigration are civil in nature. So my example of that person getting a speeding ticket in North Carolina is a misdemeanor. So realistically, we should be more concerned about that speeding ticket person with the misdemeanor, the crime, than with the overstay of the student visa, which is a civil violation. So that will help give people a little bit of the idea as to why many people use this term. And depending on the news network you watch, you're going to hear it a lot more or you're going to hear it a lot less. And just the sheer fact that you're going to hear it more or less on different networks should also tell you as to why the term and how the term is being used to manipulate people. So that's true for both sides of the political spectrum. The vocabulary that we use to refer to people sets the scale for how we're going to engage in that conversation. And whether you agree or disagree is fine, but just being aware of what it is and why the vernacular matters can be useful to engaging with somebody else who may agree or disagree. It's just good to kind of be on the same page and have that understanding and background. What countries have recently been removed from TPS? None. So they started trying to remove several when Trump was in office, but federal lawsuits stopped most of those, and then eventually he got voted out of office, and then that kind of changed back. So they tried to end it for a bunch of countries, basically almost every country, but lawsuits stopped that or delayed it for long enough, and then there was a new election, and then it just changed. All right, types of visas. So I already kind of talked about this, so I'll go through this one fast. There are immigrant visas, which is for a person to immigrate to the United States and get a green card. There are non-immigrant visas where the person has to have that non-immigrant intent. Again, the student visa, the tourist visa, J1 visa, where somebody comes to be an au pair or they come to work at Carowinds and serve hot dogs. Those people are planning to go back home. DACA and TPS, we went through a lot of this already. DACA is also worth talking about because so many people have it. Many of your coworkers or people who work in your offices may have it as well. And DACA went up to the US Supreme Court once. And the basic idea was that the administration at that point had not followed what's called the Administrative Procedures Act. So they hadn't properly gone about getting rid of DACA. The decision was not that the government doesn't have the ability to get rid of DACA. The decision wasn't about the underlying constitutionality of using prosecutorial discretion in such a broad way as DACA. But that question will come for the US Supreme Court. And the US Supreme Court has a very different makeup than the last time that DACA went before the court. So I keep telling many of my clients that honestly, if somebody asks me where DACA is going to be in 10 years from now, I don't think it will be here. I don't think we'll have it. And I think all of those individuals will have lost the protection of DACA between now and maybe much shorter than a decade. But definitely a decade from now, I don't think it'll still be here. That matters a lot because a lot of people who have DACA should probably apply for what's called advanced parole. It gives them permission to leave the United States and to come back in. And when a person has DACA, that can be done for a couple reasons. For humanitarian reasons, to visit a loved one who may be sick. It can also be done for school. It can be done for work, but humanitarian is the basis that we use most often. And the reason why it would matter for someone with DACA is if they came in unlawfully, their parents brought them when they were 7 or 8, they came in without inspection. But if they leave with advanced parole and they come back in, they now have that inspection. And if DACA gets taken away, the inspection doesn't, because it's at a one point in time when they've re-entered the United States, they've shown their approved advanced parole, they show their passport, they get that stamp, that inspection stays, even if DACA doesn't. And if that person has a US citizen kid who's 2 years old, well, in 20 years, that kid's gonna be 22. In 19 years, that kid's 21. At 21, that US citizen daughter can file a petition for their mother. Now, if the person entered in without inspection, it makes it far more complicated for them to try to get their green card. But if they had entered with inspection, they left on advanced parole and came back in, the 21-year-old daughter files a petition for them. Now they can do an adjustment of status, which is the fastest, the cheapest way to get a green card. And they can do that without needing a waiver for any unlawful presence that they have, for unlawful work that they may have had. It gets forgiven in that process of adjustment. and they get to do it without having to leave the country. So that can be very beneficial for a lot of reasons. Because for a lot of the waivers that people may need to overcome inadmissibility, you often need a qualifying family member. So a US citizen or lawful permanent resident spouse or parent with status, or children, minor children with status. A couple other questions. Are college students still charged out of state tuition while going to school in North Carolina? I believe so, but I don't know. The next one, yes. Inspection. Inspection basically means you show your passport. So if anybody's ever traveled internationally, you know, when you come back in after picking up your bags, before you get your bags, you go up to an officer with CBP. They're standing behind their little cubicle and you show your passport. They ask you, how was your trip? And they ask you, you don't have any drugs, right? You say, no, of course not. Hopefully you say, no, of course not. And then you show your passport and that's stamped. That's inspection. That means an immigration officer has taken your documents, they've looked at your passport, and you have been inspected and approved for entry into the United States. That inspection is what often matters for a person being able to do their adjustment of status. TPS, we already went through that. So we talked a little bit about quotas back at the very beginning, and this is the modern day equivalent of how they operate. So this is something called the Visa Bulletin. This is the Visa Bulletin for May of 2022, which is when I created this PowerPoint. And you will have immediate relatives, like a US citizen filing for their parent, that is just not on here. Or a US citizen filing for their spouse, not on here. US citizen filing for their minor children, not on here. Those are immediate relative categories. But there's also a preference category, and that's what all of these are. So, and unmarried sons and daughters of US citizens. So if you're older and you happen to have a 25-year-old son who's out of the country and is not a US citizen, you can file a petition for that person. You'll be in this F1 category, and let's say you are from Mexico. So I go down and I look at the F1 category. I go over here and I find the one for Mexico. If I file that I-130 today, I'm going to get a priority date in July of 2022. They are currently working on cases that were filed on January 1st of 2000. So you're talking 22 plus years back that this person has to wait before they will have a visa available in this preference category. To make matters even worse, we could go and look at, let's say, Mexico for F4. So filing for your brother or sister, if you are from Mexico, again, you're looking in January 2000. That's a lot of years to have to wait. This F2A category, this is now current. It didn't used to be a couple years ago, but that's what this C means. The C means that this person does have a visa available. I also like to refer to this chart whenever people make the argument that somebody should get in line, or that there is a line to even get in, because let's say I have a green card and I want to file for my daughter. And I file for her and I don't speak English, and I haven't had my green card for long enough to avoid that English portion of the test when I try to naturalize. I petitioned for my daughter. We're waiting years and years because I filed here as an F2B, and I'm from Mexico. In the 20 plus years that I'm waiting, my daughter decides that she wants to get married. She's going to now have to decide if she gets married before I become a US citizen, that's void. It gets rid of the I-130 because there is no category for a lawful permanent resident, a person with a green card, to petition for their married son or daughter, only their unmarried son and daughter. So if she gets married first, that's the end, it's gone. Or she's got to decide that she isn't going to get married, despite being in love, despite having one kid or two kids, or wanting to start that life, or whatever religious or personal reasons she has for wanting to get married. She now has to decide whether that's what she wants to do and give up on immigration in this category or not. And oftentimes clients will have that decision to make. What you can also see is there's a difference between countries. So even in this first column in F1, Mexico's working on cases that were filed in 2000. The Philippines is 2012. India's 2014, China's 2014, and this all chargeability area, this is basically everywhere else. So China, India, Mexico, and the Philippines are the 4 countries that most people tend to come from. And so that is why it takes longer to wait, because of that essentially quota system. I'm going to skim over here. Okay, none of those are questions. Is that a long waiting period intentional in your opinion? Yes and no. So Sue was asking me if the long waiting period is intentional. Yes, in the sense that that's how we set up our immigration system, and it was thought out for better or ill. This is the system we chose, and it's the one that we made. And because of those quotas, it also factors in that more people from Mexico are wanting to come. So some of it is the system and how it's set up, and the rest of it is, if all of a sudden everybody from Mexico decided they didn't want to come to the United States, then these dates are going to go back up. Or if all of a sudden everybody in Kenya decides that the United States is the only place they want to come from and come to, and they find a very good way to get here, then all of a sudden that'll change on here as well. So it's not on this chart, but in the employment-based category, of which there is one of these as well, there is now a new section for El Salvador, Guatemala, and Honduras. It's called the Northern Triangle. It's that area of Central America where you're seeing so many children come in without parents. And because so many people are coming from there, there's something called special immigrant juvenile status, which is if a person has been abandoned, abused, or neglected by one or both of their natural parents, and they have been adjudicated to be within the juvenile court system. So they're under the age of 18 in North Carolina, and it is not in their best interest to be taken back to their home country, then they can apply for special immigrant juvenile status. And that is a 4th preference employment-based category. And that is why on the employment-based chart, there's now a new section just for those countries. It didn't exist 5 years ago, but with the change in the dynamics, it exists now. And so that's kind of the perfect example of how the system plus where people are trying to come from, depending on economic and other circumstances, can change. Another question. Yeah, tech companies have some influence. So this is a family-based chart. So the tech companies have no influence over this one. But if I were to also show you the employment-based chart, which I have, then it would matter. So if you have an awful lot of people coming from India for the employment-based categories, now Mexico is current. It's almost the exact opposite. So you're not having as many people come in the 2nd, 3rd preference employment-based categories, which are going to be for people with advanced degrees. They're going to be for people who are at the top of their fields, as in this 1st preference, or people who have a certain amount of work experience. Now it's actually harder to come from India than it is from Mexico. So the employment-based categories are going to be different because the dynamics of where people are trying to come from. And a lot of this, in particular for India, is being driven by Silicon Valley and California looking for people with tech jobs. So that's a good question. And again, it kind of shows the interaction of the system with the economic reality and dynamics of the entire world, where all of these countries may be coming from, all people. All right, asylum. This actually also changed. So again, I did this back in May, or at least a couple months ago. So this one was talking about Title 42 and essentially that wait in Mexico. This is something that has just changed within the last couple of weeks. So the Biden administration is now going to be able to essentially get rid of that. They were being blocked in court, and now that impediment has been removed. So I don't know exactly how quickly it will be implemented or how quickly they're going to get rid of all of this on the ground, or how immediate the impact is going to be, because I just don't see it as often not practicing on the border. But I would have expected this to have a virtually immediate impact on some of the people that were at the border. So not going to talk about this one that much. The Title 42, that one I believe is still around. That had to do with during the pandemic, it was kind of used as an excuse for not letting people in, because if you don't know whether the person is vaccinated or they could be coming in with COVID-19, there's some underlying justification there, but there's also being able to use something that is reasonable to an extent that is unreasonable. And I believe in the application of some of those concepts, that's where things kind of went off the rail. And Many people kind of want it to stay for political reasons. Democrats sometimes don't want to get rid of it because they don't want to be seen as being soft on immigration, which again, it's not criminal. So there's a lot of changing dynamics politically in immigration, which can make it fun and also incredibly infuriating area in which to practice. So one of the things is also moving judges. So under the prior administration, some of the judges that had the statistically worse amount of cases that were granted for asylum were also the immigration judges that were then moved to the Board of Immigration Appeals. So if you had to appeal a decision that was made in an immigration court, that goes up to the Board of Immigration Appeals. And if you are constantly populating that Board of Immigration Appeals with the people who are the least likely to grant anything, then you're making it harder and harder for immigrants at every single level of that court system to arguably get a fair hearing, because you're essentially enshrining an awful lot of bias into that system. So that has been happening for a while as well. Pop quiz number 2. What major event happened on September 11th, 2001? So I'm guessing most people in the US are going to get that one. And then who is in charge of the executive branch? This one's probably a little bit more complicated, but the Federalist Papers supported the passage of the US Constitution. How many of you can name one of the writers of the Federalist Papers who did not see something on Broadway or here in Greensboro about it? And why do some states have more representatives than other states? And why does the flag have 50 stars? Good job, Martha. All right, next. How do criminal charges affect immigrants? So this one, again, it goes back into whether a person is admissible to the US. And there's a lot of different ways that different crimes can have an effect on somebody. So for instance, there's that minor misdemeanor, the traffic violations, and you've also got felonies. And you've got what is called an aggravated felony, which this term is not going to mean the same thing to me as it does to a criminal attorney, because our immigration definitions of what is a felony and aggravated felony are different than normal criminal attorneys. Crimes involving moral turpitude. This one's always a little bit ambiguous to try to describe, but the example I normally use is if I go out on the street and just punch somebody in the face, not a good thing, but not a crime involving moral turpitude. It's just me assaulting somebody random who I have no reason above and beyond normal human decency to not punch in the face. However, if I go out and my wife is on the street and I punch her in the face, now that's different. It tugs on all of us a different way because there's a relationship there that should be protected. Now it's domestic violence. It's that extra level of the relationship that makes that more morally turpitudinous. So you're kind of delving a little bit into the realm of ethics and meta-ethics, but that's how crime involving moral turpitude works. Sometimes a judge might say, I don't really know how to define it, but like I know it when I see it. That's how crimes involving moral turpitude work. So case laws often define whether the Arizona statute for X is a crime involving moral turpitude, whether the New Jersey statute for something similar is a crime involving moral turpitude. And oftentimes that analysis will change based on exactly how that statute is written and what the components may or may not be. But that's what the morally turpitudinous part of it means. And now you've also all learned a new word, turpitude. Petty offense. So there's an exception to one ground of inadmissibility if a person falls under the petty offense exception. Essentially, there wasn't more than a year of possible sentence that they could have had. They weren't sentenced to a specific term more than a certain amount of time. And then there's also an exception for if the crime occurred when the person was a minor. Also, oftentimes, many criminal things are technically juvenile delinquent proceedings, which is civil in nature as opposed to criminal. If a person is like an 8-year-old, depending on how that works in the given state, those things can also be different. Inadmissibility versus removability, we already talked about. That inadmissibility is your ability to apply and get status, and removability is the ability of the government to kind of take you away. One of the last things is talk to an immigration attorney. So not just a criminal one. So if you know anybody who has a green card or doesn't have status and they want to talk to a criminal attorney, that is a fantastic fantastic idea. They should do that. But also talk to an immigration attorney.
Alex, we have some questions that have been sent to me that I think kind of fit here.
Sure.
Would you mind if okay. One of the questions is, what should I do if I find out I'm going to be deported? I don't know if deported is the right word, but that was what was asked. What can you do? What should you do? What can you do?
So if the person already has an order of removal, and removal and deportation, they mean the same thing. So one of them is more commonly used where we say deported, but the technical term is removal. So if a person is in removal proceedings, they're in deportation proceedings. The form of that question kind of presupposes that they've already almost been ordered removed. So if you're at that point, there's really not a lot that you can do unless you could file a motion to reopen and had a valid reason to do so. But if you just got arrested or you just got taken into custody and you are about to be put into removal proceedings, that's a different question. Now, the first thing that they would do is that person would be scheduled for what's called a master calendar hearing. At the master calendar hearing, the judge would read the notice to appear, which is an NTA, and that's going to read the allegations as to why they believe this person may be removable. Maybe they have a felony, or maybe they are just here without permission, and that they are citizen and national of Nicaragua. And after you've read at the master calendar hearing, you've read the NTA, the judge then says, okay, well, if all of these things are true, I find you removable from the United States. And then they would ask counsel or ask the individual, now what forms of relief are you planning on applying for? And now you've gotten into the world of removal defense. So the relief that person has, you would need substantially more facts to be able to determine what it might be. If they're a 5-year-old and their father is no longer in the picture, but the father is on the birth certificate, well, now maybe they were abandoned by one of their natural parents and maybe they have special immigrant juvenile status. Or maybe they were married to a US citizen and they had never gotten around to applying for anything, which is a bad idea. But now they're eligible for either adjustment of status before the court or cancellation of removal. So the next step as to what you would do if you're in removal proceedings is A, call an immigration attorney, and B, probably listen to them.
Okay, the follow-up to that question was, in your experience, what is or are the most common reasons immigrants are deported?
Oftentimes just being in the wrong place at the wrong time. Because if a person has no US citizen or lawful permanent resident relatives, if you are just a single male who came unlawfully because you were trying to work and build a life, even if you had no real criminal record, you often have no basis to stay here. Even if you've been here for 15 years, if you get put into removal proceedings just for being in the wrong place at the wrong time or a relatively minor criminal issue, if you have no basis to stay, you have no basis to stay.
So you're just kind of out of luck.
Yeah.
Okay, we've got another question. There's actually a couple. What's the difference between a refugee and an immigrant? Given that AHA, the American Hebrew Academy, is going to be converted into housing unaccompanied minors, are they refugees? Are they immigrants? Do they get different services like healthcare, food assistance, and education?
Okay, that was like an 8-part question, so I'm going to try to take it in the order in which I remember it. So part of it is, again, our common terminology. So I've been getting this a lot because we did free consulates for more than a month for people that were from Ukraine. And so I was fielding this question of, how do I apply for asylum? How do I apply for refugee status? So oftentimes in common terms, a refugee is basically anybody who's fleeing from something. They're seeking refuge from X. But in legal terminology, in order to be adjudicated a refugee, you actually have to apply from outside of the United States. You can't apply for refugee status once you're already in the US. You're applying for refugee status when you're out of the United States, and asylum is the exact opposite. In order to apply for asylum, you have to be in the United States. So somebody who escaped Ukraine and is in Poland can't apply for political asylum in the United States until they get here, but they could apply for refugee status. And the way that's done is they might interact with, for instance, UNHCR is the refugee branch of the United Nations. And there's a pretty prolonged process to determine whether a person is in fact a refugee. That's where you get refugee camps. Once a person is determined to be a refugee, there are refugee resettlement agencies that then say, you have a relative, you have a sister in the United States in California who's a US citizen. This refugee resettlement agency is now going to work on resettling you, the refugee in Poland from Ukraine, over here to be with your US citizen sister. So that's what refugee means. But the term is also often kind of used interchangeably with somebody who is just fleeing. So to some extent, yeah, all of the kids that are fleeing just generalized violence in much of Central America are refugees from that violence.
Okay, there's a question about asylum, if we're using the term correctly, but there used to be, to this questioner's best knowledge, that you could apply for asylum if, for example, you were in a country in which being gay was illegal, and you would be killed most probably if you returned to that country because they knew about you. Is that still, is gender preference or sexual orientation still available to be considered for asylum?
Yes, I have one of those cases within the last month that just signed up. So asylum is basically that you have either suffered past persecution or are likely to suffer future persecution on the basis of your race, your religion, your national origin, your membership in a particular social group, or your political opinion. Membership in a particular social group might be somebody who is obviously or known to be homosexual in a country where that is illegal. It might be a Muslim majority country where it's extremely frowned upon, or it might be a more conservative Catholic country where it is looked down upon, or where they might suffer extreme violence from someplace in Africa where it's frowned upon. And so that can be a basis if they can demonstrate that they are at risk of suffering future persecution on the basis of their membership in this group, that they should not be required to change or are not able to change. So it might be your membership in the particular social group of a nuclear family. You can't change who your family members are or what you love.
I just got a follow-up that says, do asylum and refugee cases count against quotas?
Refugee has its own quota. So under the prior administration, for instance, we cut the amount of refugees that we were accepting to like a pittance. It was hardly any. Now it has been increased. And one of the ways that it's been increased is we're accepting a lot of people from Ukraine during this Unite for Ukraine. But we are making, the federal government sets the amount of refugees that we will accept in any given fiscal year. That goes from October 1st till the same time next year. So we set those quotas. Asylum right now is almost being limited just by the sheer processing ability. So if a person is applying for asylum in immigration court, there's an enormous backlog before that immigration judge can finalize and make that decision. If they apply affirmatively in North Carolina, the closest immigration asylum office is going to be in Arlington, Virginia, but it could be, I have many clients who have been waiting years. And back in the 90s, people used to wait a decade or more to actually have that affirmative asylum interview. So it's really more of a logjam.
Jody mentioned something in the chat and she asked a question. If you want to read it, it has the expungement question. That was one of our topics. It was our first one in the Let's Talk Law series. And she's asking, can you cover why immigrants should be cautious with expungements?
Yeah, criminal attorneys like expungements because it used to give them something extra to do. Now, at the beginning of this year, North Carolina kind of changed the laws so that a lot of things are supposed to be automatically expunged if a person is found not guilty. And I hate that. The reason being is in immigration, if you are applying for a benefit, you are the moving party. You are applying and you bear the burden to prove that you are eligible for whatever you are applying for. So if I'm applying for lawful permanent residence, the question might ask, have I ever been arrested, cited, or detained? My answer needs to be yes, if I was ever arrested, even if I was later found to be not guilty. So I say yes. And then they'll ask me why. And then I'm supposed to prove that I was found not guilty. The moment you expunge it, I have no way to prove anything because it's essentially gone. I think there are some workarounds with trying to talk to somebody in Raleigh or get copies of these things. But once something is expunged, it's supposed to be very, very difficult to find. But you still have that affirmative burden to prove that this was dismissed in such a way that it is not an immigration conviction, because things can be dismissed different ways. And some of them, for the state of North Carolina, dismissal is a dismissal. At the end of the day, it's dismissed, doesn't matter. For immigration, we operate with more nuance. So something can be dismissed by, let's say, a 1996 program, which is a drug diversion program in North Carolina. You have to admit guilt in order to enter into that program. Now, later on, if you follow all of the criteria, it will end up appearing as a dismissal. But for immigration purposes, that is 100% a conviction. So
Wow.
that can be a problem.
Okay, I'll save the next couple of questions, but I want you to please get to everything you planned.
I don't even remember how many slides are left. I think we're near the end. So I think there's a couple minutes left, so we can do whatever questions anybody has.
Whoops, I was muted. I've got a question here that is, I've got a couple, I'm just running through them. You talked about student visas and family visas. You talked about family reunification. Okay, this is actually a very helpful one. There seem to be many groups in Greensboro that work with or help refugees or immigrants or new citizens. How do I know which group to work with? How do I trust them? How do I know they're going to help me with my needs?
So if it's your needs, if you are an immigrant, then I don't know. Because let's say you're answering this question for something broader than just our particular area. There is reason to be cautious, because people who don't speak the language or people who are immigrants and are not familiar with the culture, are not familiar with how things operate, just the bureaucracy, it's ripe for them to be taken advantage of. So I think the first basis of that question, that is skepticism, is it's a good view to have and kind of operate that way. But then look around, because you can ask other people that may have been involved, or if you have other people that you trust. Let's say you go to a church and you found a church that you trust. You might meet people there or talk to a pastor, or you might know somebody at your job. So I think if you ask multiple people and you end up getting multiple responses, or multiple things point to this group as being viable and helpful, then I think you start to trust that. If you've got only one data point, or only one person says it, or it's the shady person smoking weed behind the garbage dump outside of Wendy's, don't trust that guy. Like, find somebody a little bit more reliable to get your immigration and refugee help from.
And
Okay, I've
Alex,
got-
if I could jump in, you've talked about the
Sure.
notarios before.
Oh yeah.
I mean, there are people pretending to practice law or saying that they're qualified to practice law, offering immigration support. And I mean, it's a scam, right?
Pretty much. I mean, the thing is, sometimes they'll get things right, and they get things right enough that it's dangerous. Because if you went to somebody and all they ever did is mess up every single case, they're going to stop having people go to them. So what Jody was referring to is, in Spanish, notario just means, oftentimes means a person who is an attorney. In the US, in order to get a notary, you just have to go to an 8-hour class at UNCG and pay $40 for your stamp from Staples. But you can say that you are a notary, but if somebody hears that in Spanish, they will often think that this person is an attorney and that they're giving them immigration advice. And one of the best ways you can tell is if I get a copy of their paperwork and it doesn't have the person who prepared the documents' names on it, then I almost know that somebody else took the money for preparing the form. They took that and they didn't put their name anywhere, because they know they shouldn't have been practicing or giving any immigration advice. So you have to beware, because there are no real consequences for that. If we screw up your case, if I make mistakes, I answer to the state bar, and I value my bar license quite a lot. So it is in my best interest to handle your case to the utmost ability that I have. You don't have those same consequences for somebody who's a notario. They may not have gone to law school. and they will not have a bar license. So it's a very different level of caliber that you're going to get. And oftentimes they might be well-intentioned as well. So I don't want to completely make it out that this is somebody who's intentionally trying to hurt somebody, because oftentimes somebody who does the most damage is somebody who was really trying to help, but they knew just enough to be dangerous and to mess something up in such a way that they can really cause permanent problems.
I have one more question that shouldn't be real complicated. It shouldn't be. It says, I'm undocumented and need medical care. What should I do? I
That
think
one's
that
almost more
question
of a-
means, will doctors turn you in?
No, that's not likely, but I think it was almost asking more of a benefits question, like how can I get resources? Because oftentimes if somebody has no status, they might have to go to an emergency room, which ends up being extremely expensive. If you have no social security number, no bank account, your ability to access private health insurance is basically non-existent. So it does get very difficult to get access to many things, because you are essentially living in the shadows when you're undocumented. That's why Daca mattered so much for those people who could come out of the shadows, because they can get health insurance, they can get health care because they have a social security number. It makes it easier to buy a house. And I honestly don't know what all of the means that people who do not have status use to navigate day to day. And I can't imagine how hard it actually is.
Can you give a short description of what an orange card is?
No, because I don't really
Okay.
understand what it is.
Yeah.
I know it has something to do with health.
Jody, I think Jody can.
Yeah, so the Orange Card Network is something that we have. It's unique to, I think, this area. Other areas might have something similar, but it's local. And it's essentially a network of doctors who volunteer their services. They volunteer a measure of their time. So if you have to apply to become a part of the Orange Card Network and to become a patient with them, and then they'll refer you to different people, whether it be dentists or specialists within the Orange Card Network.
Thank you.
Mhm.
Okay, I put a link to a survey in the chat. We do this survey at the end of every session. It doesn't take 5 minutes. If you would please fill it out, it really helps us when we're planning. Alex, is Susan Edmondson related to you?
Yes.
And we'd like to recognize her. I think she's been here the whole time. And I'd also like to say thank you to Mary Kay Abuswader, who is at just about everything the Human Rights Commissions and CSW and everybody does. And if you don't know Beth Bowles, Beth is a librarian at the Central Library, I believe. Beth, can you just briefly tell people about the languages you speak and who you focus on?
Oh my goodness, I wasn't, can you hear me?
Yeah, absolutely.
Yeah. I want to take a moment to praise Alex. Every time I see this presentation, I learn something. Thank you so much, Alex, for what you give. I speak Spanish and French, and I work at the library, and I work with Jody at the city for trying to make sure that residents of the city can access all city services regardless of any type of language barrier that they may have.
No, thank you. I
Yes.
think we have 120 something languages spoken in Greensboro. And that kind of blew me away. I would have thought much less than that. Immigration, immigrants, new Americans, new citizens. I'm so glad that you were all here tonight to learn how difficult it is, like Alex almost ended with, it was perfect, how they navigate what they do every single day. So I really appreciate you taking the time, Alex. It was fabulous. It'll be on video if you want to share it with your friends, but please go click that survey and you'll get it in an email afterward, because Jody always does that in case you didn't fill it out, but they are really helpful to us. So it is 7:26. And if you don't have any questions, any additional questions, we're going to call it a night. And thank you very much for being here. And we hope to see you in the fall when the next series starts. It'll be a 5-part series called Let's Talk Access, how do we get access to things in Greensboro? Okay, have a good night. Jody, hang on for 1 minute and I'll see you all in Zoom.
Good night, all.
Everyone, thank
Good
you,
night.
Alex.
I thank you for inviting me.